Well, that's the major talking points over the weekend. Well, that's what we're starting off with here today on Sunrise Daily. And Chief Mike Ozekhome, a senior advocate of Nigeria, joins us from our studios in Abuja to give some perspective on this matter. Morning, Chief, and thank you for joining us today. Let's take us through this because, I mean, they cited Section 177C of the Constitution saying they did not fulfill that, and as such, he is not the governor.
Yeah, good morning and very much. Let me start by saying that Nigeria operates a constitutional democracy, which means that we go by rules and regulations. We don't operate in the Herbacean state of nature, where life was short, nasty, and brutish. And the Constitution is the ground norm of the country. That is the apex of all the laws, the supreme law. Because by Section 1, Subsection 3, if any other law, the Electoral Act, is inconsistent with the provisions of the Constitution, that law will be null and void. Section 177 of the Constitution of the Federal Republic of Nigeria, 1999, that you refer to, provides or makes provisions for the qualification of who can contest for the governorship of a state. And what it says is that for a person to contest, to be qualified to contest for the governorship of a state, he must be a Nigerian citizen, he must be at least 35 years old, he must possess educational qualification up to at least school certificate. And listen to this, he must belong to a political party which must sponsor him. In other words, this means that independent candidature is excluded, a matter that we fought for very strongly at the national conference last year, and we succeeded in driving through in the over 650 recommendations, which I'm praying that that President Muhammadu Buhari's government will implement. We brought in independent candidature so that even if you don't belong to a political party and you are popular and your people feel you have done well for them and you want to contest elections, they should allow you go and contest. But it's not like that. Section 177 says, no, you must belong to a political party and it is that political party that must sponsor you. How do they sponsor you? Will be the next question. That takes us to the Electoral Act. Two laws govern elections in Nigeria, the Constitution and the Electoral Act. The Electoral Act in Section 85, subsection 1, says that a political party wanting to hold a congress or a conference or a convention must give 21 days notice to the Independent National Electoral Commission, INEC, that, look, we are going to hold a convention, conference, or congress. By virtue of Section 85, subsection 2, INEC may, with or without, note these words of the Electoral Act, INEC may, with or without prior notice to any political party, decide to attend its convention, conference, or congress and observe what it is doing. May, in law, for those of us who are not lawyers, is interpreted to mean something that is permissive, that is not obligatory, that is not mandatory. In other words, INEC may decide not to go and observe the political party's convention or congress if it so wishes. It may. And it can do so without even prior notice of that political party. Now, having gone to hold this convention or congress, what is the next? What are they going to do there? For purpose of what? For the purpose of holding primaries. That takes us to Section 87, subsection 1 of the Electoral Act. That section provides that any political party wanting to field a candidate for any election must hold primaries from which that candidate must emerge. And the primaries must be conducted in such a way that they are democratic, whether you call it direct primaries or indirect primaries, and the various ways, details of how these direct or indirect primaries are also stated in sections 80, 85 in various subsections. Having heard those primaries, let us now assume that there is a dispute as to whether there was proper nomination or election of a candidate to emerge from those primaries. What do we do? Section 87, subsection 9 provides an answer. It says, any person of a political party who believes that the provisions of the Electoral Act have not been complied with in terms of the election or selection or nomination of a candidate at a primary shall approach the Federal High Court or the High Court of that state, of course, that has jurisdiction, to complain that, look, these primaries have not been well held. The nomination or selection or election of candidate A or B or C was not proper. We want you to set it aside. That makes it what you call a pre-election matter. It's a matter that you go to court to challenge before the elections hold at all.
All right, Chief, let me bring in this, having made that point, because there are those who are giving their interpretation saying, as a result of this judgment, they have come to the conclusion that it is now settled that this that qualification and disqualification is now both a pre- and post-election matter, and it has concurrent jurisdiction, which is exercisable by both the election tribunal and the High Court.
I was coming there. Thank you. I was coming there in my interpretation, by God's grace, as a constitutional lawyer. Now, there are conflicting decisions by appellate courts as to whether that matter under section 87.9 is just pre-election.
Okay.
Others have argued, and there are many other judgments also, that it could also be post-election, in which case the Election Petition Tribunal, trying that very gubernatorial case, also has jurisdiction to look into that matter. That is not disputable. So let us say, therefore, for the purpose of our argument this morning, or for the purpose of elucidation, that the Taraba State Governorship Tribunal did have jurisdiction to hear the matter between the governor, Darius, and the challenger, Mrs. Aisha Alhassan. Let us, for the purpose of argument, say that tribunal had the jurisdiction. The next question that should be of utmost interest to Nigerians is, what is the outcome of an election petition when you find out, for example, that Darius did not win, that it was Alhassan that won? That takes us to section 140, subsection 1 of the Electoral Act. Section 140, subsection 1 of the Electoral Act says, the tribunal, if he feels that a candidate who won an election was not properly elected